Good evening, everybody. Well, I say evening. If you're in North Carolina, it's about 8 o'clock, so about an hour from my bedtime. I'm an early sleeper. But my name is Carmen Peterson. I am a fellow Syngapian parent. You guys probably haven't seen a whole lot of me, but I am an estate planning attorney based in Michigan. I have a virtual firm that focuses exclusively on estate planning at this time. And one of the big things that has come up, especially being a special needs parent, is special needs trust. So I'll be talking about just a little about estate planning, but the bulk will be about special needs trust, the benefits, why you need to have one, and what the purpose of a special needs trust is. I don't think that estate planning in and of itself is extremely complex, but the special needs trust is a little bit more advanced and a little bit more complex. So I'll just give you kind of a high level explanation of what it is, and then would hope that you would be able to go and talk to an attorney that's in your area. But because I'm only licensed in Michigan at this time, I won't give any specific legal advice. This will just be kind of a high level explanation of what it is, the benefits of it. And then if you talk to someone in your area, they should be able to give you more information about what your state law says about special needs trust and just estate planning in general. So seeing as how it is 8 o'clock, clearly, at least here, this is not super long, long drawn out webinar. I want it to be really casual. If you have questions, you don't have to hold them to the end because I don't want you to forget them. There may be something that somebody else is thinking about too. So if you could ask those in the chat or raise your hand, we can get those in before I move on to another section. So I don't have an in-depth presentation, but I do have something for you to look at. So I will share my screen if that is okay. Give me 2 seconds. It appears I'm in the wrong spot. There we go. Okay, and now I have to go back to share. Oh, I just pressed it right there. Okay, can everybody see that?
Yes. Sure can.
Yes, great. Okay, obviously everybody can hear me. Okay, so perfect. Okay, so let me just move this over a little bit. Put that over there. Okay, so estate planning is is really just a way to make sure that everything that you've worked your tail off for is distributed as you want it to be, and that your children and your family are taken care of when you transition. It is a fact that we are not immortal and that we will all transition at some point. So estate planning gives you a vehicle to be able to sit down, look at your assets, look at your children, look at what their needs are, and sort of plan around that so that when you do transition, there are essentially no questions about what you intended and what you wanted to happen with your children and your assets. So I always like to say, and this came from somebody else, and I can't give them credit because I don't remember the name, but the goal is not to live forever, but to create something that will. So this is just a really short and to the point diagram of what an estate plan is, or the most common things that are in an estate plan. Most of us have heard of a will. It's probably the most common thing that you hear about. You hear about it all over TV, people leaving all sorts of things in their wills. We've all heard the term trust fund babies, which came from having a trust and kids being left, property and resources in a trust. Um, Durable power of attorney and healthcare power of attorney are kind of similar. They do different things. A durable power of attorney is going to be for legal and financial decisions, where you just give somebody else the ability to step in your shoes and to make certain decisions. And in both of those documents, you have the ability to limit those powers or to make them as broad as you want. The healthcare power of attorney is the same thing, but it's only for healthcare and medical decisions. Life and burial insurance are really not, I mean, those are self-explanatory, but they're really not a part of the estate plan, but oftentimes they're used to fund things like the trust. They're often, left as a sort of resource in a way to take care of obviously those that you leave behind. And burial insurance is just one of those things that obviously you can use just for burial expenses, so it doesn't cut into life insurance and other things that you may have left behind for certain family members and friends. Guardianship designation, I talk a lot about this because the whole point when you have minor children is to make sure that they are cared for in your absence. And that doesn't just mean life insurance and money and, assets. That means that you have named who you want to care for them in your absence. And sometimes maybe that is a couple, maybe it's a friend, maybe it's a sibling. I mean, whoever it is, the idea is if I leave here and if I'm married, if both parents are deceased, that this is what, these are the people that I would want to take care of my children. And you have the ability to also, make out certain information that says, this is also how I want you to do that. And a lot of times that's where these trusts come in. And so just before we get to the special needs trust, are there any questions about anything that I just said here? Okay, good. So there are several types of trust. And I didn't name it here because again, there's so many different types that do different things. Some have, issues with whether you're trying to avoid taxes or whether you are, again, planning for a child who has special needs, or whether it's a trust that you have that just holds assets and properties while you're alive. And then once you die, it becomes irrevocable, and then it just distributes however you've laid out. And so those are just, some of the things that we use trusts for typically that are not necessarily just special needs trusts. So the whole point with special needs trust is to make sure that the assets and the resources that you leave behind for that child is protected. And what I mean by that is we want our children to be able to have access to Medicaid and maybe other state funded programs or federally funded programs, which could be Social Security. There may be other community programs, and those programs are always going to look at need. So if you leave $200,000 in a just a regular trust, well, when they start to apply for those other programs, those programs are going to look at what assets and resources they have. And likely with that amount of cash on hand, they would certainly deny them for those benefits. So the purpose of the special needs trust is to be able to leave those resources behind, make sure that they're not excluded from those other programs, and that they're basically able to supplement their way of life without losing out on those other benefits. And so that's the whole goal of a special needs trust. Questions about that? I know that was a whole mouthful. So this is, so the biggest thing to take away from, you kind of look at a special needs trust as a way to make sure that your child is taken care of financially once you transition. And I know as a fellow, Syngapian parent, I often think about what happens when my husband and I are no longer here. And this obviously does not address their, actual care, but it leaves the resources behind for someone to be able to step in and pay for additional things that, those government programs will not pay for. So with the trust, obviously, you need somebody who's going to dole out whatever resources that you leave behind. So that would be called a trustee. And that's just going to be essentially the gatekeeper to the trust. So essentially a trust is kind of like a document, and oftentimes is, held at a bank, and you can just put things in it, whether that's, say, your life insurance goes directly into the trust when you die. You name that you name the name of the trust as the beneficiary to that life insurance. So that money goes in there and it's held in that space, and nothing happens to it. It doesn't come out, it doesn't, expire, anything like that. It stays in that space until the trustee makes decisions about what to distribute, how to distribute that, and who it goes to based on the parameters that you set. So if you say, if it's a special needs trust, there are certain parameters that have to be set by law, but the trustee has a lot of discretion to be able to pay for certain things for that child, based on the resources that are in there and your state, because your state laws are going to have something to do with it, as well as if they are eligible for those means tested programs, which are going to be your Social Security, your Medicaid, those type of things, maybe other community programs. There will be certain things that they just won't pay for. Those things oftentimes pay for the bare minimum. And so this gives the opportunity for a trustee to be able to pay oftentimes directly to those other service providers. That could be education, that could be vacation, that could be household furnishings. Obviously, not if they have Medicaid will pay for certain things, but on, outside of the things that Medicaid would cover, that these funds would be able to be used for that. That stuff will go directly through the trustee. And oftentimes, the money won't ever change hands with that child, because as long as they have basically the ability to have somebody else use their discretion to dole out those resources, it can't be counted against them as them owning it, although it's for them. So a trustee could be anybody that you name. It could be another sibling. It could be, it could be another parent if there's a two-parent, household, and one of them should pass away. You could name the other parent. You could name a friend, another family member. There are also things like corporate trustees, like a bank. But oftentimes they won't get involved unless, the amount for the trust is at least like $500,000 or, $1 million, like really high, for them to get involved before they will sign on as trustees. And so, the obvious thing is, even myself, I always think my oldest child would be perfect to be trustee for Ethan, which, if you guys don't know, this is a picture of Ethan, one of my favorite little pictures of him, when he used to love bubbles, bless his heart. And so I always think that about my daughter. The reality of it, though, is and we'll, my husband and I will talk more about this, but sometimes you want to be careful about who you pick, if they're siblings, because you don't want to create a conflict of interest. You don't want sometimes them to have the burden of it, but also other times you may think, this is the person that's going to be closest to him or her once I'm not here. I think they will certainly do right by them. And you not have to worry about that, because the other thing is, because it's a trust, it's not under the purview of the court unless there's a dispute. So there won't be anybody necessarily, any court necessarily going over all of the information for the trust and all of the distributions and all those types of things, like they would if it was a will, which, you know, has to be probated and go through probate court. When there's a trust, the court is not involved at all. Any questions about trustee, who can be trustee or anything like that?
That seems like it's very has a lot of potential for corruption.
So it
Am
does.
I like overthinking it, or
Oh, you're not.
like what's the
So
best way to prevent that? Because I
you
feel
have
like anybody that gets all of a sudden $1 million, say for instance, has potential to make bad choices with it or get excited and maybe use it in a way they shouldn't use it. So
Yeah.
how do you overcome that
Right.
objection?
Can I comment on that too? I happen to have two special needs trusts for my sister that I'm her guardian and I'm a co-trustee.
okay.
So this week I had to for Medicare renewals every few years, and they literally want a copy of the receipts, every bank statement, and they want to make sure they want to see how the money's spent. And every year for Social Security, I have to do a full accounting of every penny spent in both the trusts and also every receipt. Now I'm missing two receipts this year, and they let me slide by that because it was Kohl's. So obviously clothing, but it's really it's a lot of work. So I feel like some people just refuse to do it. I don't know if they stop paying Social Security at that point or they don't get their Medicare, but it is grueling. I bought Karen large men's socks, and they questioned, why did I buy men's socks? I said, well, they have larger ankles and her ankles are swollen. But I had to literally explain everything. But it all worked out fine. It worked out fine. And I've been doing this for a few years now, but that's just one example of a question they might ask. And
what happens before
yes.
that kicks in? So for instance, you know, if heaven forbid they're under 18, who is then looking over that to make sure what's going to them is supposed to go to them? It's just a trust factor, hence the name.
Well, I think as was just pointed out, now see with Medicaid or Medicare and Social Security, they're looking to make sure that this person continues to be eligible, basically making sure that you're paying for the right things, making sure that whatever money is coming out of the trust is for that person. But I think they're looking at it more so not to make sure that you are the best trustee, but to kind of protect themselves, in the sense that the whole idea of any kind of, you know, these government run programs is that they are, you know, that you're not paying for, or this person doesn't have access to this money, especially if it's, and so that it's a resource counted against them, especially depending on the type of special needs trust, which we'll talk about a little bit when I get to the next slide. But you're right. I mean, obviously, and I was going to say that Social Security, not Social Security, yeah, Social Security has been relentless about sometimes rejecting special needs trust if the language is not correct. And obviously on the back end, when they're looking, is it every year that they're looking at it now to make sure? So if they're looking at it every year,
yes.
So again, yeah, in that part, I didn't know that they looked every year at, because I know once you set it up, if they're already getting these things, then they have to approve it. And, you know, look at it, and they are oftentimes rejecting it. Now, I don't know about everywhere else, but in Michigan, the Department of Human Services is not as nearly as bad or as restrictive as Social Security. And I don't know that necessarily the reasoning behind it, and I'm sure it probably varies across the state. But you're right, there isn't a whole lot of checks and balances with the trust, which is why, excuse me, you have to pick somebody who's going to be responsible and do exactly what they're supposed to do, because then they run that risk of the special needs individual not being eligible any longer for those services.
Is it possible to pick two people?
It is. It is.
That way that's sort of a check and balance, like
well,
Nancy
assuming
said,
that they're not like husband and wife.
Yeah.
So there's that. I mean, not saying that obviously if you're husband and wife, you're corrupt, but they may not be as, the checks and balances may not be as strong if you're dealing with a husband and wife versus maybe two siblings who may be looking at the other like, hey, you need to make sure the money that's coming out of here is appropriate and for the appropriate things based on the parameters and the requirements set out by these, Social Security and Medicaid, Medicare, and whatever other community programs may have those certain types of requirements. Because I think you said you were a co-trustee. I'm sorry, I didn't catch your name.
Yes, Nancy Kessler,
okay.
and I am a co-guardian and co-trustee with our other sister, but
Okay.
She doesn't care to be involved, so which is fine. But the one thing about naming two people is when I did set up the accounts in the bank, and my other sister lives in Florida, it was difficult to get her to sign everything and to open it correctly. So, but it is always, I think, a good idea to have a backup. But
absolutely a successor
it still
trustee.
creates, it's still a successor trustee, which is, if we had known that language, we would have done it that way from the start.
Okay.
I think maybe you can explain that one, because I think that is a good idea.
Absolutely. So a co-trustee is going to basically be, it's kind of like co-borrowers, like both have the same types of responsibilities to the trust. And I would assume that unless there's other information or requirements that say different, they both would be able to, make withdrawals, and basically have the same amount of authority over the trust, what comes out, what goes in, that kind of thing. With a successor trustee, that basically says that if something happens to one person, like I name, I'm going to name, in my situation, I would likely name my oldest daughter. But if something happens to her, or if she just decides, I don't want to do this, I would name my second son as successor trustee, who would be able to step in her shoes if she decided she didn't want to, or for some reason was unable to. So it's always good to have a backup on anything, because you never know what's going to happen, especially when you're talking about estate planning. Other comments about that? Thank you so much for that, Nancy. I think it's always good to have a real world lived experience when you're talking about this stuff, because in a vacuum, sometimes I think it just seems like, just another thing, and it may not make as much sense.
Yeah, I agree.
Okay. Okay, so there are more than one type of special needs trust, but I think that often, whether it's a first party or a third party trust. So a first party it's the special needs individual's money. Sometimes you get like a lawsuit settlement, maybe for personal injury or an inheritance from somewhere else. And so the big difference between the two is going to be whose money it is. And then oftentimes with a first party, because it's the beneficiary's money, there's a Medicaid payback. And essentially what that means is at the end of that special needs, at the end of the beneficiary's life, whatever is left in that trust, the state has first dibs. They go in and look at what's left and say, okay, we're going to recoup basically the money that we've spent on Medicaid over your lifetime. So that's the only way that you are able to essentially own the money or resources that are in the trust and still be eligible for these other programs that look at basically your need. When you're talking about a third party trust, and these are the ones that I see that are more common, is oftentimes when it's parents or grandparents leaving money for for the special needs individual. So it's not the money of the beneficiary. Oftentimes it comes from life insurance, from parents, 401k proceeds, investments, property, anything that's basically being gifted to them is not theirs. And that's the whole premise of the third party, is that the funds or the resources come from another party other than the beneficiary. And so for those, there are no Medicaid paybacks, because it wasn't the money of the beneficiary, that, when they got Medicaid, it wasn't their money or assets, resources, those types of things that were in the trust. So that's the big difference between the two. Questions about that? Comments?
There was a question in the chat that asked, do you have to wait until someone turns 18 or can it be taken out before?
You mean the money that's, I'm assuming that they're asking the money that's in the trust.
Can a special needs trust be set up before someone turns 18?
Absolutely, absolutely. And so there are a couple ways to do it. There's no, if you have a special needs child, there is no time that is too soon, because the trust doesn't go anywhere. Say they, that you don't expire anytime soon. And, the idea is that you have this trust set up before the child needs it, obviously. Because, again, life is fleeting. We don't know the time or the hour. So if that child, like Ethan right now is 6, and I know some of us have younger children, this would be a perfect time to set that up. And a lot of times, like we talked about, kind of some of the trust proceeds and resources come from life insurance. So that will go directly into the trust. And nobody ever knows, when that may or may not happen. So you would have that set up. It would flow directly into that trust. And then the trust, basically, depending on the amount of resources that are there, would basically cover the lifetime of the special needs individual, assuming that there is enough in there to cover that.
One question too, this may be a bit early to ask. So if a grandparent, say, has a life insurance policy, can they, and say I have a trust set up, can they make that life insurance policy automatically go into an existing trust?
Yes.
Somebody else's?
Yep. Okay. So what they would do is name that trust as a beneficiary. So that just means that when they transition, that life insurance will go directly into that trust. There will be no issues with any other person, because again, just like when you name any other type of beneficiary, the trust is its own entity. So you can name that trust and it'll flow right into it.
So is it better for them, instead of them setting up a trust, for them to just feed into?
So I think so I think the thing is that it's always going to depend. And a lot of times it depends on family dynamics, and how the grandparents or the parents kind of want what they want that to look like. Because again, if it's the grandparents' life insurance, they may have somebody that they want the trustee to be that may not necessarily be the parents. You know what I mean? And because it's their trust, if they set it up for the benefit of, of their grandkid, then they can pick who that trustee is. Or if everybody was on board and they just wanted one central trust, absolutely. The parents could set the trust up and then they would just name that just name the trust as the beneficiary to those life insurance proceeds. When they transition, it flows right into the trust. The only thing is, and again, if everybody is on board, then it's not an issue. But oftentimes, what I find with different families, they have different ideas on how they want that money to be distributed, how they want it to be spent. And as a result, if they were to put it into your trust opposed to having their own, they don't get a whole lot of say-so as to the parameters of the trust. Because if it's your trust and you're setting it up for your daughter, then in theory, you and your husband would be the one that would be making the decisions as to the parameters on that trust and who the trustee was. But if there was a situation where you guys all decided to get together, you decided who the trustees were, you decided what the parameters were, and everybody was okay with that, as long as everybody's okay with that, there's not a problem with the grandparents leaving that life insurance in that trust.
Awesome.
I know that was a whole lot, but the short answer is yes. I mean, you could have a number of trusts. The only thing that is in my mind that is paramount is that they're done correctly so that they do what you intend for them to do. Okay, and so we talked a little bit about this already. And I think, most people are already familiar with Social Security, Medicaid. Even if you don't have Medicaid, generally you are aware at a high level that it is, health insurance by the state, and that Social Security, oftentimes as special needs individuals age and they're unable to care for themselves in terms of, working, that they would be eligible for SSI, which will cover basic needs, but that's the point of the special needs trust, to kind of supplement those other benefits, because those, oftentimes, as we know, will only meet the bare minimum for needs. And especially, I'm assuming, and maybe I'm wrong here, but, as our children grow older, the things are, obviously going to be more expensive. And I'm just curious to know just how much these other community and state-based programs will continue to move up in terms of, inflation. I know they will have to, but it's just, I don't want to think about, my kid necessarily going without if I haven't the ability to put together a vehicle that will be able to supplement those things, to, help them have the best quality of life that they can possibly have. Okay. So I just was thinking about how to pare down like some of the most important things about special needs trust. And I think that we've talked about all three of these things, but the three things that I think are really important to remember is that an outright gift to a beneficiary, which is a person that you're giving the gift to, in this situation, either your kid or a grandkid, a niece, nephew, what have you, could mean the loss of eligibility for these government programs, which is the whole point of a special needs trust. I was just talking a moment ago about the special needs trust being drafted properly. And part of it is because, again, as Nancy talked about earlier with Social Security, some of them are, and it probably also depends on who's looking at it, but some of them can be really treacherous when they're looking at the language in the special needs trust. So the big thing about a special needs trust is we know what it's supposed to do, but the attorney is the person that is tasked with the the big issue of making sure that everything fits together in a way that does exactly what it's supposed to do, and that it meets the requirement of Social Security and Medicaid or Medicare. And that is the part that obviously that you have no, really no say so in, because as if you're not an attorney, you don't necessarily know exactly what should be in that trust. And so you want to make sure that when you pick somebody to draft a special needs trust, that you find out just what their experience is, and whether or not they, this is something that they've done, something that they are comfortable doing, how well versed they are in not just estate planning, but the Medicaid rules, the Social Security rules. I've seen situations where social special needs trust, the language is kicked back by Social Security, but not by DHS. And so again, although they're similar in terms of what needs to be in there, it really just depends. And ideally, if it's rejected, they would tell you exactly what the issues are, and that you'd be able to essentially fix those issues. But what you don't want to do is you think you have this special needs trust that does everything that you want it to do, only to find out that they are disqualified in that moment, either from being eligible for it, in terms of trying to get it, or at that point being kicked off of these programs because they're not eligible based on the language in the special needs trust. And so
you said,
oh, I'm sorry, go ahead.
Sorry, you said that if you'll find out, how do I word it? You'll find out that there's issues when they go to receive the governmental services.
Essentially, yes.
That means that someone has passed away in order for that trust to be kicking in and finding out that it's causing problems. How do you adjust a trust after the people that have created it pass away?
So, okay, so a couple of things. So, just because a person you've set up a special needs trust, doesn't necessarily mean that the people who have created it have passed away. Because in theory, you could have a special needs trust and, the grandparents may still be living. And they put this money away, but maybe at that point, depending obviously on ages, I'm talking in hypotheticals here, but depending on the age, they may be, a young adult who's already, they're over 18. They're already maybe, possibly getting Social Security. They may be eligible for Medicaid, depending on, the parent situation. So not always is it everybody has transitioned and there's no way to change the trust, but that is a possibility. Absolutely. And so that's why you want to make sure that whoever you pick to do these trusts, that you make sure that, oftentimes it's going to, a good way to go is recommendations. You may not always have the option, but that's why you're always trying to make sure that whoever it is that you trust to do this, that they are capable, more than capable of making sure that the right language is there, so that it doesn't conflict with Social Security and that you don't have any problems. But I think the bigger issue and the answer to your question with estate planning in general, oftentimes there is no way to find out that it's not right until people are dead. And so that's why, you don't want to go to places like LegalZoom. And I've even seen now on the QVC channel, they sell everything. They had like a will and trust kit on the QVC channel.
Oh, Lord.
I was outdone.
12 payments of $39.99.
Exactly. So again, it's one of those things that it's a lot of times it's a big investment, and it's something that's so important that you oftentimes you won't even look at this stuff again generally, unless, there's some big life experience. I mean, you should get it updated, but if there aren't any updates, you generally aren't, sitting and talking to an attorney, and it's usually the same attorney, assuming that you had a good experience. And so there may be issues that you wouldn't even know was an issue. You leave here thinking that everything is set up the way that you intended, and it's not, which is why it's never a good idea to do anything regarding estate planning as a do-it-yourself. I would always obviously say get a reputable attorney, and I'll give you some tips, kind of towards the end as well, about things to look at with attorneys, and which I think would be helpful in picking somebody who knows what they're doing and what they're talking about.
We have a few more questions in the chat, Carmen. One of them was about, that's okay, and you may even be getting to it, but one of them was about whether or not, let me go back and read it so I don't mess it up. One of them was about how to actually set up a trust. So I know you said you have to find a reputable lawyer that could do that. But as far as the bank is concerned and all of that, are there, like, what is your first steps and what does that look like? And then the second question, and I'm telling you both at once in case you're going to get to them, was about similar to what Corey just talked about. But let's just say that your special needs child passes before that you have the trust for, and they want to know what would happen to the trust. Would it go back to the parent? Would it go back, like the person that set up the trust? Would the government try to take some of it? Are there any legal complications, like if your child were to pass before then? So,
okay.
over to you.
Okay. Tell me that first question again, because that last one was a doozy.
So the first one was just about the steps to getting a special needs trust. So we know we have to find a reputable lawyer, but what do we do with the bank and so forth and so on? So,
so a trust is a bit of a complex thing, right? So ideally, the attorney that you find will be able to walk you step by step through everything. And that means from A to Z. So essentially, when you meet with an attorney, they're going to find out what kind of assets you have. Generally like an intake questionnaire. You fill that out, you tell them about all the assets you have. You then also tell them about your family dynamics. Maybe you have other kids. So maybe you want to set up a special needs trust, and maybe you have a trust, maybe one or two, depending on how many kids you have, or because you can do separate trusts, or you could do, I would never recommend doing more than one thing. And as it relates to a special needs trust, that's going to be its own animal. Other types of trust sometimes can be combined, but you could do, if you have other kids, you certainly could do just a regular, like a revocable living trust for other kids that don't have these special needs, because of course those trusts are not going to have those same parameters. So once they find out what your family dynamics look like, and because you're typically planning for the whole family, it's usually not just, one, assuming that you may have more than one child or other people that you want to leave things to. So essentially, you're the driver. You tell the attorney what you're thinking about in terms of how you want to leave these assets, and then they basically tell you what the legal vehicles are to get you from point A to point B. So once they've figured out what assets you have, who those family members are, and the family dynamics, and how you want to distribute those funds, they would draft up the trust. And then typically the second part of that is funding the trust. So all that means is putting whatever resources that you want in the trust. So that is something that can also be done by the attorney, where you never have to worry about it, or they can give you the directions and the steps for you to do it yourself, which again, you're taking a big risk. by funding a trust yourself, because ideally, if that part is not done right, you'll have a trust and won't have anything in it. Because you either, didn't title things correctly. Maybe you didn't list it right on the life insurance, so it doesn't flow into the trust. So oftentimes, if you have the funds to do it, it makes sense to have the attorney just handle all of it. And so essentially, as a result of that, once everything is, kind of said and done, you leave with a document that shows, all of the parameters, everything that's listed in the trust. And from there, once you have that trustee on board, that person is able to basically direct the trust as you have laid out in the trust documents. So an attorney is going to be able to tell you exactly what you need to do based on how you want to handle things. I hope that answers that. If not, let me know. I can, if you're looking for something else, certainly let me know. In terms of a death of a child or special needs individual, before they get a chance to use it, because I think that was the question, before they get a chance to use the special needs trust. Yes, the parents or grandparents, whoever put into that trust, would be able to take those resources out. So the thing with the third party trust, where the funds in the trust don't belong to the special needs individual, it still technically belongs to whoever gifted those funds for the benefit of that person. So if something were to happen to the special needs individual, and before they got a chance to use it, yes, you'd be able to amend that trust, terminate it, take those resources out. The only time that you have a problem with taking resources and money and things out of a trust is if it's either starts off as an irrevocable trust that you can't amend, or I won't say necessarily amend, but you can't terminate because it's not revocable. Or if you start off with a living trust, a revocable living trust, once the person who owns the trust, once they die, or when the person that started the trust, once they die, then it becomes irrevocable. But for a special needs trust, a third party trust anyway, where other people have put things in there, it's technically not owned by the special needs person. It's technically owned by the people who put the funds or resources into that trust. So that wouldn't be a problem for them to, retrieve the resources from that trust, should that happen. But if it's and this kind of goes back to first party or third party. If it's a first party and that person dies, which just means that it's their money, it came from a settlement, an inheritance, something, anything like that, then the state has first dibs on the remaining amount in that trust, assuming that they had, used Medicaid, insurance, or Medicare. So they're trying to recoup that money, which is a little bit different than the question, but I wanted to be thorough. Did I answer those? Okay, because I can revise my answers if you need more information.
I believe you did. And then I just had a question. I'm sure this varies state to state and lawyer to lawyer. But if you were thinking, I know you said it's a costly process, but if you had a range that you could give us, what does this typically cost? Like, what if we were to go to someone and they gave us an outrageous amount versus someone that gave us too cheap of an amount? Like, what is the typical amount that we could look forward to paying to get this done?
Yeah, is it based off the amount of trust you're putting in there, or is it based off of the amount of complexity in the writing of the trust?
So yes and no. ideally, special needs trusts are going to be more expensive than, let's just say, a revocable living trust, which is a lot more common. It doesn't have these parameters. It's basically just you saying, I want to put this money in this trust. You name beneficiaries. You could be the trustee of it. There are no issues with any Social Security, Medicaid, none of that. It's just simply you putting things in trust, and then naming beneficiaries. Essentially, that's the very condensed version of a revocable living trust. But those are relatively easy when it comes to trust because they're the most common. They don't have a ton of detail that has to be there to make sure that they don't run afoul of some other program that you're trying to also get resources from. So typically what you're going to do is you're going to run, and again, this does depend on where you live, because like if you're in a California, everything is more expensive in California, just point blank period. There's no way around that. But one thing I will say is that it's going to depend on the attorney. And it typically does not depend though on how much you're putting in there. Because the idea is with special needs trusts is just that they're more complex because of the different language and parameters around a special needs trust because of the the Medicaid and the Social Security and those types of things. That's the only thing that really makes it that much more difficult. And then sometimes, depending on whether it's a first or a third party, you might have to worry about, paying the state back. So there are so many different layers. So I would say you're always going to find somebody who's going to do things cheaply. And I would always recommend that you stay away from those people. And I only say that because you run up against either somebody who is going to be inexperienced, so they're not going to charge you a lot. B, they're trying to get volume, so they're charging lower amounts, which could mean that they are not giving your special needs trust or your estate planning in general as much time and detail as it deserves, because they're trying to get enough clients in to be able to make a living. I mean,
like going to an H&R Block versus going to a private accountant.
Right. It's the same thing. So oftentimes I would say find somebody in the middle, somebody that's not, necessarily price gouging or just, charging you several thousand extra dollars because they can. Because oftentimes, and I won't say that they won't do top tier work. A lot of them will, but you can oftentimes still find that in the middle as well. It's just the bottom sometimes that I think you have to be really cautious about. So I'm going to tell you what my range is. I don't know typically what everyone else charges. And again, it's going to depend on locale a lot. And then you have some attorneys who also deal with people with a higher net worth who are going to automatically just charge more. That's just, just kind of what it is. But it's, typically they don't range based on, how much you have in assets in terms of, this specific trust. So mine started at $39.95. And I think I am in the middle. I'm not the lowest and I'm definitely not the highest. And oftentimes there are, what's the word? Payment plans, financing, depending on the attorney, would typically offer some of those things. Because to be able to drop $4,000 with special needs kids might not be doable for everybody right away. And I hate the idea of a special needs tax, because I feel like anything that has to do with special needs automatically is like bumped up, and you're just like, really? Like, we're already always paying so much more for everything that has to do with special needs. But this is the one investment that I would say with special needs that you're going to want to walk away with that peace of mind, feeling like, okay, I'm looking at the value that this is going to provide my baby, in theory, for the rest of their life when I'm no longer here. So you have to look at, I think, the value of what it is that you're getting. And when you look at that value versus somebody that's going to charge you $1,500 for something that usually starts at least $3,000, you want to be really careful about that. That's, my take on it, but they can get costly, quickly. And I think even $39.95 is, and that may be, I mean, I'm dealing with, mine is in the middle based on Michigan prices. And so I don't know what it is, like even in North Carolina, for instance. And sometimes, in the South, things tend to be just a smidge cheaper sometimes. But I think it really just depends on where you are and the type of attorney that you work with.
Okay, on that note, there's two more questions in addition to mine. So when I did my conservatorship for my daughter, we went through a program where they did not necessarily low cost, but like it was because my husband and I are both military, and we were able to get like a discounted rate for our conservatorship. But it was more of I guess what I'm asking is if you went through not necessarily a company, because I honestly think it was like through the city or like it was through a reputable program. So let's say you go through a reputable program and they offer some sort of discount as far as that's concerned based on like eligibility requirements or something. Would that be the same as looking for the cheapest rate per se, or would that still be considered as long as it was a decent place to go to that knew what they were doing?
So oftentimes with programs like that, even so I'll say this. I think that some of those programs are excellent, and some of them will even contract with private attorneys, and they get kind of a special rate because they're connected to this program. So it's not, and so I should absolutely rephrase that. Not everybody who is not charging middle of the road prices is not going to do a good job. I'm absolutely not saying that, because I think there are some very good programs that recognize, especially as special needs parents, military families, certain things like that they are dedicated just to those things. And oftentimes they get grant funding and other funding and things like that kind of make up that difference. What I was thinking about was private attorneys that are off on their own, sometimes, who will just, give you a lower price to get you in the door, not necessarily be very experienced and not necessarily worried about your best interest as much as they should be.
Right. So you may have like lawyers that are working with the program that are still reputable and okay to work with that. Yeah.
Yep.
They just
absolutely.
Okay. And then, so two other questions that we had come up is a trust like a savings account where you'd be able to add to the account?
So I guess that's a good way to look at it, maybe. Yes, you can absolutely add to it. Yes. So in a sense, I think that's a good way to look at it, where you can add and kind of take out. But as Nancy talked about, when you are taking out, you better be darn sure that you're writing it down. You have receipts, and oftentimes with special needs trust, it just makes more sense to pay providers directly, because then that way you also have kind of that paper trail. And those are, you're certainly, depending on the child, obviously, are not giving out, cash outright, given, just cash amounts to that specific individual. And oftentimes it makes sense, because the reason that it's in a trust is because sometimes they just don't have the ability to basically be able to handle the money anyway. But when you, as a, you know, as you're paying providers and those types of things, you are making sure that the money is getting exactly where it's supposed to go, and it doesn't look like that person has the discretion to be able to basically stick their hand in that account and take, you know, money and funds out. So, I mean, I guess in that sense, absolutely, that's a good analogy.
Okay, and then the question similar to that was, does it earn interest like a savings account would?
You know what? That is a good question that I don't have the answer to.
It wouldn't, well, it could potentially gain in value if your home gains in value. It would go with the market of the home if that was what you were leaving. If it's a life insurance policy, it's a life insurance policy.
Well,
I don't know.
If it's a life insurance policy, so you're not putting the actual policy in there. You're only putting the proceeds in it. So when it actually, you know, that person transitions, that money goes into that account. It's kind of like a contract between the life insurance company and the trust, basically. So they just pay that money out into the trust. So the proceeds could potentially earn some types of interest or something like that. That makes sense. I don't think I've ever looked into that part of it, though, in terms of with the special needs trust anyway. Interesting.
I
that's
can
to look at.
Yeah, I can speak to the two trusts that I do have for Karen. One of them is earning interest and the other one isn't, because I wouldn't want to have to, if it earned a lot of interest, then you'd have to create an income for her. And I was told that I might have to do a tax return for that. So
that makes sense.
That's why, yeah, that was the first special needs trust, the first one.
Okay.
But the third one does earn interest.
That makes sense. Yeah. And that's the thing, is that everything that you do with special needs is always kind of set around them not getting too much in the way of income, because then they get disqualified for those programs. And so that makes a lot of sense. And I don't think that I've ever had to even deal with the interest part of it. But that's really interesting. But yeah, you always have to be careful about whatever is happening with, you know, that special needs individual and the resources that can be attributed to them. Just because you don't want to disqualify them, make it look like they have more resources or access to the resources, even if it is for their benefit.
And if I could just mention that, because it's watched so carefully and Karen does not have all of that income and all those resources.
Thank you. My foot is not.
Oh, okay. But she's able to get amazing services because of that, because it's really, you know, kept under the $2,000 limit, and she has everything's covered for her. She has everything.
That's awesome. And that's the whole point, right? I mean, there are a lot of things, I think, especially as special needs parents, that we can't control. This is one of those things that we do have it's a vehicle for us to have some control, to try to make sure that they're at least financially cared for when we're no longer here. Okay, so we did talk about this earlier, about certain things that the funds can be used for: housing, transportation, uncovered or extra medical services beyond whatever is paid for Medicaid, supplemental educational services, supplies, furniture, electronic items, vacations. And this is all going to be at the discretion of the trustee. So a lot of that goes back to the trustee. And Nancy sounds like a wonderful trustee. She's keeping, you know, everything together, making sure that, you know, she is, you know, being responsible and accountable for whatever is coming out of that trust. And so, and that's obviously the type of person that you want to be, to act as trustee. Okay. So we talked a little bit about this earlier. So selecting an attorney is just like we do with doctors, right? I don't know about you guys, but when I buy a $2 thing off of Amazon, I'm looking at the reviews because I want to know that my $2 is going to be well spent. And that's just me. I look at reviews for everything. Reviews that you can get into that's gonna and again, not all reviews are created equal, but if they're all saying the same thing, that this attorney takes your money and doesn't get back to you, well, my guess is that this is not who you want as your attorney. But the other thing that you should always do as well is make sure that you're checking the state bar, whatever state you're in, to make sure that the attorney is licensed and in good standing. And so you want to make sure that they don't have any disciplinary actions, which is something that is typically listed on the state bar's website. I know that this is kind of a way just to make sure that essentially, if there are issues like, them, either taking people's money and not getting back to them or not responding quickly, people will file, complaints, basically. The state bar is kind of like the Better Business Bureau. Goodness grief, excuse me, guys. State bar is like the Better Business Bureau. Something happens that you feel is not on the up and up, they're going to be kind of that checks and balances for you with every attorney. So I think that's just kind of baseline type of things. I mean, a lot of times we go through a lot of doctors, neurologists, pediatricians, developmental pediatricians, and I've always looked at the reviews for those doctors. Just to kind of get an idea of what I was walking into. I mean, and then obviously, just like anything else, you go in and you talk to these people, you trust your gut. They give you a scummy feeling, you can find somebody around the corner, I promise you. Go with your gut on that when when you're talking to people. Attorneys are certainly no different. Because this is going to be a big investment. Even if it's not terribly expensive, it could cost you a lot in the end if they are not up to par, if they're not competent to be able to do what you're hiring them to do. It could cost you a lot in the end, a lot more than whatever that initial investment is going to be. And I would just say, ask questions about some of the things that we've talked about here. It's always going to, in my opinion, is always going to be the best way to kind of figure out at least who knows what they're talking about. And this is the thing with, attorneys, doctors, we're not walking encyclopedias. We don't know everything off the top of our head. I mean, that's why we have a million books that we can go and look at. However, there should be some basic things that they should know and be able to explain to your satisfaction. And a lot of times you usually, can tell if somebody can't, if they can't answer basic questions about what it is that you're trying to do. That could be a problem. If it's something that's nuanced and they say, okay, let me look this up and get back to you or what have you. I mean, that makes sense. I mean, we don't know everything. And every family is going to be different. Every, kind of situation is going to be different. However, there are going to be certain things about special needs trust that we kind of just talked about that won't change, even from state to state. So just be mindful of that when you're talking to people, and then look for recommendations. I mean, I know for me, like I'm in several groups with with kids that have autism. So I mean, Syngap One, this is an awesome group. But I also have some local people who, children who have autism or epilepsy. And, a lot of times some of these other parents, they already have special needs attorneys. They have, there are local people who are sometimes in those groups, also attorneys who can answer questions. So there is a way to find somebody who's experienced, who's not going to price gouge you, and who's going to essentially just do what you need them to do. And so, approach this like anything else, with reading the reviews, looking at the state bar, making sure they're good on those two fronts. Those in my mind would be the first two things that you look at. Everything else is obviously, you're going to go with your gut, just talk to them. And because a lot of people have, the free consults. And so that's a good time to just talk to people and just see if you like their energy. Some people right off the bat, you'll know this is not somebody I want to be fooling with. Especially not on something like this is not a traffic ticket. The worst, if you're dealing with an attorney who's not great, and it's a traffic ticket, well, chances are you're not going to jail. You might get some points, but this is, a little bit more involved. So I would say, talk to them, fill them out, just like they're looking at you as whether you could be a good potential client for them. You should be making sure that you're also interviewing them to make sure that they are what you need them to be and that you're going to be able to trust them. Because there's nothing worse than, putting down money, a big investment on something that's super important like this, and then second guessing whether they are doing what they're supposed to do. And then, I've even had people come to me for second opinions after they paid a whole nother attorney to do the work. That gets really expensive really quick. So, I would say look at these things on the front end, and then, check for those recommendations too. Because chances are if somebody has used them and got a good result, chances are that is, you're par for the course. I mean, it's likely that you would also get, a good result. Other questions?
Somebody asked in the chat, is it possible for a lower income family to create a special needs trust?
You mean like on their own?
It doesn't specify, it just said.
Okay. So what I would probably say is, anything is possible. I would never recommend that you try to do this on your own. I understand it is super important, right? But sometimes what you can also find are attorneys that will do some of these things on a sliding scale for kind of like low bono or even pro bono that do good work. It's just a matter of finding them and basically making sure that that you feel like they're competent. Again, you're looking at those things that we just talked about. And maybe this is not something that they, always do. But this is certainly something that that they, will consider. Even for my firm, what I try to do is offer my services in situations where parents are, low income. I can't do it all the time, but I do try to set aside a portion of, or percentage basically, of some of the other packages that I do to try to be able to offer that, because it's important and it is expensive. But the other thing I would encourage is that if you have the ability to possibly, finance, some attorneys offer that in-house, or they may have a payment plan that you can do. And so all is not lost because they are expensive. But I think like any other investment, you can make it happen if it's of importance and value to you, and or finding an attorney who is able to offer, and some of those programs that we were talking about earlier that may offer these things. So I would just say do your research on those if this is something that you're really interested in, but just don't have the funds to do it just yet.
And then another question. Okay, someone said they have a question about an older child.
Mm-hmm.
I just wanted permission to speak because
yeah, go ahead.
Hard to text. So my daughter's 20 years old, and I live in Canada, so a lot of what you said is very different than what's here. It's called a Henson Trust here,
Okay.
and I have to go and get one done. And I'm wondering if it's ethical. So my daughter has some money in her account that is just sitting there not being used at the moment. And like you said about, accumulating any wealth, you certainly don't want to do that. You think it's ethical for me to use some of her money to purchase her own, well, I would say living will, Henson Trust? Or do you think that's unethical?
Why would it be unethical? You're helping her.
Yeah, I don't necessarily, no, but I know what you mean. So
Instead of using the money currently on her, you would be putting it up for a later date for her. But to me, it's still used for what it was
It's
on her
so
intended.
behalf.
beneficial.
Yeah, it's on her behalf.
Yeah.
But
yes,
I don't know. I just have like,
I know what you mean. So this is what I will say is that there are times that when there are going to be let's just say you're trying to qualify for these government programs, and I don't know how it's set up in Canada, but I know that there are times when they will look back for a period to make sure that people aren't transferring assets or hiding assets or what have you, so that people are eligible for those programs. This is a situation where I think that as long as you keep a paper trail of what it is and what it's used for, I don't think you're going to, necessarily have an issue with that. If it's something that you are, planning to get done with an attorney, call an attorney and ask them. Do a free consult and talk with them about it. Because I certainly don't want to give you any information here that could go against anything that you're doing, especially since it's another country. But I would say if you're going to do anything like that, just always keep receipts, kind of like Nancy was talking about earlier. And I know I keep going back to you, Nancy, but I just think that was like, I just love the fact that there was somebody in here who had already, had been kind of working with that. So I would always say for something like that, just keep the records of it. But if you're truly worried about, I don't think unethical would not be the word that I would use at all for that. But if you're worried about somebody looking back later and saying,
Okay.
so I don't necessarily think that you would have an issue with, it being unethical. But keep a paper trail. I would ask, if you are planning already anyway to go and get the trust done, I would talk to the attorney about it. Maybe just do a free consult over the phone to find out if there would be any ramifications or issues with you doing that.
Okay, thank you.
And then I was wondering, is it possible, like my daughter has a certificate that her grandparents set up, and when she was born, I'm not quite sure what kind of certificate, but yeah, probably more like a bond. Is it possible to get that transferred into a trust?
I don't see why not. I don't see why not. There are very few things that you can't put in a trust. So I don't see that would be an issue. Other questions?
This is great. I feel so much better.
Well,
even though I hadn't done it yet, I still feel better.
Well, I'm glad that you guys feel better. That was the idea. Congratulations on even sitting through this thing, because I know it is very difficult to think about a time when you're not here and your kids are still here. But I think you would feel a lot better if you had things set up and done, knowing that, okay, if I slide out of here tomorrow, my baby's taken care of,
Yeah, it takes away that anxiety element.
Yeah, because there is a little bit anyway, because there are obviously always other things that you can't control. I don't care how many trusts you have, but this is one thing that is a big part of their life that they lose once you're not here. It's just that, those resources. And so if there's a way to make it easier for them to have a better, quality of life, even though you're not here, I think it's worth at least looking into. And again, look for those low cost programs. If it's not something that you're able to outright afford or, save up for it, finance it. I mean, I hate to even think about having it. I think it was a root canal I had to have done years ago, and it was $5,000. And I was like, okay, well, there is no waiting. Like, I can't really wait and save up. It is like this gonna have to be done right now. I mean, nobody likes root canals, but it had to be done. You know what I mean? And so obviously the value of, you know, a properly done root canal is invaluable when you look at it, you know. So there's nothing like mouth pain. There is nothing like it. Even childbirth, and I've done it 3 times, and I'm telling you, they're running neck and neck for me, but that's just my own personal experience. But the idea is just, yes, you know, just if you can make the room for it, if it's important to you, because it is valuable, and I think it'll be really helpful in the long run. Well, if that is all, and I didn't talk y'all's ear off enough, oh yes, because y'all,
I think there's one more question.
Okay.
Do you know if there's a type of savings account that doesn't count against benefits of disability? Meantime, while I can search for an attorney where we are in Texas.
So I don't know about Texas. Like Michigan has what's called, and it might be, and I don't know if it's just Michigan. They call it an ABLE account. And so essentially, this could be for, you know, children who may be higher functioning. But what you would be able to do is basically put resources into this account. And then they would be able to, you know, like get enough out to, you know, maybe get a haircut or buy some clothes, those type of things. Now, in terms of it counting against them, again, I don't necessarily, and I would have to look at it again to know for sure. But any kind of resources like the Social Security and Medicaid is they're serious about these, you know, them having resources that are attributable to them. So you would have to look at the specific programs and the parameters of that specific programs. I don't know anything about Texas. I'm sorry. But I would Google special needs saving account and just see what comes up there. Because there are, and they're starting to kind of pop up more and more for these types of programs, but I don't necessarily know the parameters or how they intersect at this very moment. Because like that ABLE program in Michigan, and I think they have another one called TrueLink, are newer. And so I would have to look at the intersectionality of the two and the issues that might surround. But oftentimes those programs, certain programs, you're probably not putting, you're not putting $50,000 in those accounts. You know what I mean? Like those small accounts are for you know, higher functioning adults who may have, you know, some issues with money, or maybe, you know, people trying to take advantage. So they have the ability to, you know, get a few dollars out, but it's not anything major. And so I would just recommend looking at that and just kind of seeing what you can come up with. And then oftentimes there are different programs in the community too that will give you some of those answers that you're looking for. Hopefully Texas, I mean, as big as Texas is, hopefully Texas has some of those programs that would be available. I'm sorry that wasn't more help with Texas. I will make a note to kind of look at that though. Where's my, and I've lost my pen somehow. Oh, here it is. Are there other questions?
That's all that's in the chat, unless someone wanted to ask you specifically.
Okay.
Thank you, Carmen. This is great.
Thank you.
You're awesome.
Thank you guys so much for listening to me ramble for an hour and a half.
No, it was very informing and greatly appreciate you taking the time to answer our questions.
Absolutely. I will come back anytime you guys want me to.
Thank you so much.
All right. Have a good night, guys.
Yes, ma'am,
Thank
you
you.
too. Thank you,
Bye.
everybody, for attending.
Thanks,
Bye.
thanks Heather
Bye.
for facilitating.
You're welcome.